Part 2. This gets even better. Mr. Harvey's expectation at the time of instruction was that this review would incorporate a case note review. He could not foresee how they could fulfil their brief without doing one. With the benefit of hindsight, Mr. Harvey accepts that the letter of instruction should have been explicit as to the requirement of case note review. It is accepted that by Ms. Eardley that she was aware from her initial discussions with Mr. Harvey about the consultant's concerns regarding the commonality of one nurse. Her interpretation from her initial conversations with Mr. Harvey was that the consultants had raised the possibility of potential harm based on correlation. The RCPCH were provided with unfettered access to staff on the neonatal unit, including the consultants, to explore all the circumstances in relation to the increase in mortality. Having spoken with the consultants, some members of the RCPCH review panel formed the view that Letby's presence on the unit at the times of the death was nothing more than a commonality which, uncorroborated against all the other information they were provided with. They emphasised that the consultants had provided a mixed picture about Letby, and that when looking at the context as a whole there were, quote, no red flags, end quote. The RCPCH highlighted a number of issues on the NNU which were consistent with the Trust's own internal investigation findings, including problems with the neonatal environment, staffing level and serious incident reporting. Having had the opportunity to meet with neonatal staff, including Letby herself, the RCPCH raised no concerns about her or any other individual. There appears to have been a misunderstanding between the RCPCH and Mr. Harvey as to the identity of those whom the RCPCH's report could be shared. Mr. Harvey's understanding from previous correspondence with the RCPCH was that the version of their report which referenced confidential HR issues relating to Letby was for very limited circulation, and that only the formal version, which excluded those issues, was for dissemination to those who had contributed. Mr. Harvey was reliant on the expertise of the RCPCH and followed what he understood to be their advice. Notwithstanding that advice, it is accepted now that the report should have been shared with the paediatric consultants at an earlier stage than transpired. As to why the RCPCH report was not shared with the families sooner, Mr. Harvey explained in evidence that until a full case review had been completed, he did not consider that the requirements of the report had been fulfilled. He explained that he felt uncomfortable with sharing the report until he was able to provide a much fuller picture and pass on all relevant information in respect of their babies, so that the senior managers, quote, weren't leaving any details hanging or unanswered, end quote. Notably, the evidence from some of the parents was that they felt the RCPCH report did not answer their questions about the deaths or go into specifics. This was precisely the feeling Mr. Harvey had wanted to avoid. It is a matter of deep regret to the senior managers that some parents became aware of the report when it was leaked by others to the press, and in some cases were not aware of it until it was raised in other legal processes. The senior managers are profoundly sorry that this was how some families came to learn of the report. This should not have been the case. At the time the report was leaked, the senior managers and others had been in the process of formulating a detailed communication plan to ensure that all parents and stakeholders were notified of its completion. Mr. Harvey instructed Dr. Horden to conduct a detailed case note review. There is a difference in the recollection of Dr. Horden and Mr. Harvey as to what was communicated to her about the nature of the paediatric consultant's concern and the time of her instruction. It does not appear to be disputed that Dr. Horden had been placed on notice of a review into staff with access to the unit in the 4 hours before each incident. When asked in evidence whether she was surprised to see this, she said it would not necessarily indicate criminal intent and could be looking into, for example, clinical competencies. That was precisely the view that the senior managers had formed. Dr. Horden suggested in evidence that she had been aware of a concern that a member of staff had harmed babies deliberately. This would have triggered a much more detailed conversation about whether she could have accepted the instructions. It will be a matter for the chair to determine how reliable this evidence is in circumstances where concerns about Letby were based solely on her presence on the unit at the time of the incidents, which was within the detail of the documents provided to Dr. Horden. It is notable that she appeared to express no surprise in her email exchanges with Mr. Harvey in 2017 when addressing suspicions about Letby. This is evident from Dr. Horden's response to Mr. Harvey's email dated Valentine's Day 2017, in which he refers to the paediatrician's allegations against one member of staff. Quote, "I perceive a combination of understandable professional pride regarding standards of care on the unit, along with concern over unexpected and unexplained events, both of which are entirely reasonable reactions, but both of these should not prevent accepting and learning what could have been improved." End quote. Dr. Horden provided her initial report to Mr. Harvey in October 2016. Her evidence was that her review revealed a varied clinical picture, raising concerns in clinical management, including the use of antibiotics, delays in escalation, and whether babies had been born in the right unit for the level of care they required. This, compounded by the view of senior managers that the cause of unexplained deaths and collapses was likely to be multifactorial in nature. Whilst Dr. Horden went on to say that she agreed with the view later expressed by the paediatric consultants that her report did not explain the deaths, she did not convey that to Mr. Harvey at the time. Dr. Horden was asked whether, had she received her own report, she would have recognised the significance of the grouping of babies she had identified requiring further forensic review. She suggested that the recipient should have identified that there was, quote, "a problem here," end quote, which necessitated triggering the safeguarding process. The senior managers submit that the only problem raised by Dr. Horden's report on any reading of it was that there were issues with the clinical management on the unit which may have caused or contributed to the incidents. During further questions from Mr. Skelton Casey, Dr. Horden suggested that by grouping unexplained deaths, she was in fact saying that something other than medical cause was in play. She said there were a number of possibilities that she was not in a position to comment on, which were for the trust to look into. If these were her views at the time, they were not communicated to Mr. Harvey either explicitly or implicitly by the tone of her report or correspondence thereafter. Mr. Harvey was keen to ensure that there was further consideration of the unexplained deaths, and therefore he contacted Dr. McPartland, a consultant pathologist at Alderhay Hospital, on the 21st of December 2016 to request a review of the deaths of child I, O, P and A. Dr. McPartland and her colleagues undertook a review of these cases from a specialist paediatric pathologist viewpoint. Dr. McPartland was asked in evidence about the initial post-mortem investigations of babies and the information provided by the paediatric consultants when those deaths were reported by them. She explained that a pathologist is very reliant on the information provided and that it would be very difficult to pick up that a death was potentially suspicious without something very concerning being highlighted. She noted that it was open to the paediatric consultants to raise any concerns they had about the conclusions reached at post-mortem. The consultants at the Countess had raised no such concerns. Dr. McPartland was asked whether the cluster of deaths ought to have raised any concerns. Her evidence was that without knowing that any of those deaths were unexpected or unexplained or concerning in any way, a cluster alone would not necessarily raise a suspicion of an inflicted mode of death. With regard to the review of 4 cases undertaken at the instruction of Mr. Harvey, Dr. McPartland explained that the pathologists involved in the review did not know why 3 of the babies had collapsed, but that no concerns about the nature of the deaths were raised from the pathology reviews alone. The senior managers suggest that it is implicit from that evidence that the simple fact that a neonate had collapsed and died without explanation was not considered by the pathologists to indicate something unusual or concerning. Mr. Harvey has candidly accepted that the way in which Dr. Horden's report was shared with the families was unthinking and insensitive. He has expressed that he was keen to share the information as soon as possible, particularly in view of the delays, but accepts that this does not excuse the way in which this was done. He wishes to reiterate his apologies to the families for this. The inquiry has sought to examine whether the commissioning of various external reviews was appropriate. Mr. Harvey accepts that none of the external reviews were specifically designed to identify deliberate harm. As set out earlier in these submissions, it is a matter of regret to Mr. Harvey and the other senior managers that the police were not contacted sooner. However, it is worthy of note that when the police were contacted and eventually persuaded to investigate, the chief investigator and, more latterly, expert witness, retired paediatric consultant Dr. Dewey Evans, was able to identify evidence of murder based on his interpretation and analysis of the very same notes and records which had been considered by the RCPCH investigators. The neonatal pathologists at Alderhay Hospital, whose post-mortem examinations were considered by coroner Nicholas Reinberg to be as thorough as those conducted by forensic pathologists. Dr. Horden and Dr. McPartland, none of these neonatal experts had noticed anything of the sort. It was not unreasonable for the senior managers to have regard to the professional conclusions of those highly experienced in neonatal matters. Whilst none of these reviews specifically excluded the possibility of criminal activity, none of them identified behaviour which positively supported the possibility of a malicious act. It had been anticipated by the senior managers that, in the event there had been a malicious or negligent act, evidence of it would have been flagged up by the reviews. Instead, the reviews undertaken internally and by the RCPCH, Dr. Horden and Dr. McPartland pointed towards significant clinical concerns and suboptimal care. The view shared by the senior managers of the various reviews, when taken together, was that they pointed away from deliberate harm and towards a natural or clinical cause. Information provided to the coroner. By January 2017, the internal and external investigations were complete. The genuine belief of the senior managers at this time was that the effect of those reviews was to point away from deliberate harm and towards natural causes. On 10th of February 2017, Mr. Chambers received a letter from the consultant paediatrician stating that they did not consider that the reviews had adequately explained the deaths. They invited the senior managers to ask the senior coroner for Cheshire to undertake an investigation. It is worth noting that the initial notification of a death requiring a coronial investigation should occur immediately after the death. It is worth noting that, isn't it? The responsibility for making a report to the coroner lies primarily with the treating clinician, who is best placed to form a provisional view about whether the death is unexplained or unnatural and may need further investigation. The senior manager's understanding was that a number of babies had post-mortems identifying a natural cause of death, and it had been considered by the treating clinician or the coroner that no further investigation was necessary. In relation to the 7 babies, Letby was ultimately convicted of murdering. A. The death of child A was reported to the coroner by Dr. Salidi. An initial post-mortem found that the death was unascertained. A full inquest took place in October 2016, during which the senior coroner concluded that the death remained unascertained. B. The death of child C was reported to the coroner by Dr. Gibbs. This was done by way of a coroner's authorisation form 1, which identified the cause of death as respiratory distress syndrome. A post-mortem was undertaken, recording the cause of death as widespread hypoxic ischemia damage to the heart/myocardium due to immaturity of lung due to severe maternal vascular underperfusion, or MVUP, severe intrauterine growth restriction was listed as a contributory cause. Intrauterine growth restriction. The coronial investigation was discontinued after the post-mortem suggested a natural cause of death. C. The death of child D was reported to the coroner by Dr. Newby. This was done by way of a coroner's authorisation form 1, which noted that this was the 3rd neonatal death in 12 days, a reference to child A and child B, and that there had been a further, I think that's actually supposed to say child C, and that there had been a further episode of apneic event and CPR for a previous twin death, with the surviving twin receiving successful CPR. A post-mortem was undertaken, recording the cause of death as A. pneumonia with acute lung injury. The coronial investigation was discontinued, but later recommenced at the request of child D's family. Dr. Z.A. completed a coroner's authorisation form 1 in which she recorded the cause of death as necrotising NEC and prematurity. No post-mortem was requested and no inquest was opened. The death of child I was reported to the coroner by Dr. Gibbs. This was done by way of coroner's authorisation form 1. Quote, born 27 weeks early and has been in hospital since birth, has underlying chronic lung disease of prematurity and intermittent bowel obstruction. Doctor is not clear as to why arrest has happened and cannot issue a certificate. End quote. A post-mortem was undertaken, recording the death as hypoxic ischemic damage of brain and chronic lung disease of prematurity due to extreme prematurity. The coroner determined that it was not necessary to hold an inquest into the death of child I. The deaths of twins child O and child P were reported to the coroner by Dr. V. Post-mortems were undertaken which identified the cause of death for child O as 1A, hemorrhage to peritoneal space due to rupture of subcapsular hematoma due to prematurity. The death of child P was attributed to prematurity. Both deaths were due to proceed to an inquest hearing, but in the event, these did not take place. The senior managers understood that the coroner had been notified that there had been an increase in the number of neonatal deaths and had been provided with a copy of the thematic review. The senior managers were not involved in the preparation for the inquest into the death of child A, which fell to Stephen Cross, who instructed external lawyers to assist with that process. It is notable that Dr. Jayaram gave evidence before the coroner and raised no concerns about deliberate harm. In his evidence to the inquiry, he explained his position as follows, quote, "I was aware that the deaths had been, I think bar one of them, had been reported to the coroner, and I was also cognizant of the fact we had been told do not speculate, and again, hindsight, I didn't specifically say I or we as a group are concerned that an individual member of staff is causing harm. I was trying to make it clear to the coroner that I did not understand what was going on here, and I couldn't think of a clinical explanation, and there had been other things like this as well, but I didn't explicitly say that." Question. Stephen Cross's email, which was forwarded to you, made it clear he was direct communication with Mr. Reinberg? Answer. Well, it gave me the impression that the concern we had, the specific concern regarding Letby, was on the coroner's radar. Now, I, in retrospect, don't know whether that is the case or not, because I have not been party to discussions. But certainly, my understanding is that the coroner was aware that a very detailed case note review was going on because nothing else clinically could be found. End quote. The evidence of the senior managers was that if Dr. Jayaram was concerned that child A had been deliberately harmed, that information should have been explicitly shared with the coroner, rather than, quote, trying to sort of throw as many breadcrumbs as possible to the coroner for the coroner to pick up without explicitly saying what the suspicion was, end quote. A failing accepted by Dr. Jayaram in his evidence. On the 15th of February 2017, Mr. Harvey and Stephen Cross met with the senior coroner, Mr. Reinberg, and the assistant coroner, Mr. Moore, to discuss the consultant's request for an investigation. During the meeting, the senior and assistant coroners were provided with a bundle of documents, including Dr. Horden's report, the letter from the paediatricians dated 10th of February 2017, and a document headed Observations Additional to the RCPCH Review of Neonatal Services. The final document included the green text from the RCPCH report setting out the consultant's allegation that Letby had been involved in the deaths in some way. It is acknowledged that there is a difference in recollections of those in attendance at this meeting as to what was discussed. Mr. Harvey's clear recollection is that the topic of conversation was the events surrounding the consultants writing their letter seeking a referral to the senior coroner. As Mr. Harvey explained in evidence, he had to explain and provide documentation to support why the consultants had written that letter and were requesting a meeting with the coroner. There is no evidence to support any suggestion that the coroner was, at any stage, deliberately misled by any of the senior managers. Any such suggestion is refuted in the strongest terms. Moreover, the allegation bears no weight in circumstances where it is accepted that the senior coroner was provided with a document which made explicit references to the consultant's concerns. Reporting to the police. It was agreed during an exec team meeting on the 27th of March 2017 that the Trust would report the consultant's concerns to the police. Prior to contacting the police, Steve Cross instructed Mr. Medland KC to provide advice. It is accepted that seeking advice from Mr Medland KC ultimately caused further delay. However, the senior managers emphasise that this was done on the advice of Stephen Cross, and with their understanding was that their central purpose of his instruction was to provide advice as to how to approach the police. The senior managers ultimately approached Cheshire Police via a CDOP police representative in April 2017. That's Medland, I think. This led to Mr Chambers making a formal request in writing to the police to open an investigation into the deaths at the COCH. And there were a number of follow-up meetings between members of the senior exec team and Cheshire Police. It is Mr Chambers' recollection that the police were initially reluctant to commence a full criminal investigation. This is consistent with the evidence of Stephanie Davies. The minutes of the meeting on the 5th of May 2017 between Mr Harvey, Stephen Cross and Chief Superintendent Nigel Wenham. Sorry, I think it was Nigel Wenham who was the member of the CDOP team. Record in the summary section, quote, "If Cheshire Constabulary involved, then it would be deemed an investigation. There are no significant concerns to suggest any unlawful acts. It appears a series of anomalies that needs to be investigated further," close quote. At a further meeting on the 12th of May with Cheshire Constabulary, Assistant Chief Constable Martland noted that there was nothing in the reviews to suggest significant negligence or a criminal act. He also noted that he felt, quote, "uncomfortable," unquote, about speaking to the families of the babies without a specific allegation at that point to suggest a criminal act. Sir Francis KC gave evidence about the bureaucratic burden of collecting data and passing it on to regulators, which he described as immense. This data is designed to ensure there is openness and transparency about key metrics and to alert external bodies to any concerning trends. The Countess, like other healthcare providers, had a system in place to manage this data-driven exercise, which included mortality statistics. When there was an escalation of concerns about the rise in neonatal mortality following the death of child P in June 2016, there were various discussions with external regulatory bodies to make them aware of the situation. The senior managers were mindful of the lack of any evidence that Letby had intentionally harmed any babies, but they felt that it was important to raise an awareness of the actions they were taking to seek to establish the likely cause or causes of these deaths. Evidence has been given about the discussions held with NHS England, NHS Improvement, the CQC, the NMC and the Department of Health and Social Care. Each of these bodies was made aware of the concerning rise in deaths on the NNU and the actions being taken to seek to investigate the issue and also to make sure the unit was safe. It is noteworthy that none of these bodies advised that a safeguarding referral be made. The NMC were also told about the consultants' concerns that a number of staff presented a, quote, "serious risk to public safety," end quote, because they were the body responsible for regulating Letby and they could have imposed restrictions on her practice. This did not happen. Closing remarks. We understand from what has been publicly stated by the CCRC that an application has recently been made to the CCRC by Letby's legal representatives, received on the 3rd of February 2025. This application relates to all of her convictions arising from the period of June 2015 and June 2016 whilst at the Countess. The CCRC has begun work assessing the application and it anticipates further submissions being made. The CCRC is not able to determine how long it will take to review the application. In light of this information, the senior managers have written to the Secretary of State for Health and the chair of the inquiry requesting that the inquiry be suspended or paused pending the outcome of the CCRC's consideration of an application made by Lucy Letby in respect of her criminal convictions. Both are empowered under the Inquiries Act 2005 to effect a pause in proceedings under the following sections. Under Section 13 of the Inquiries Act 2005, the Secretary of State has the power to, at any time by notice to the Chair, suspend an inquiry for such period as appears to him to be necessary to allow for a. the completion of any other investigation relating to any of the matters to which the inquiry relates, or b. the determination of any civil or criminal proceedings, including proceedings before a disciplinary tribunal arising out of any of those matters. This power may be exercised whether or not the investigation or proceedings have begun. Before exercising this power, the Minister must consult the Chair. We submit that the CCRC's consideration of Letby's application amounts to, quote, any other investigation relating to any of the matters to which the inquiry relates. Given that the terms of reference of the inquiry are conditional on Ms. Letby's criminality, and that being the cause of the deaths and unexplained collapses of babies present on the NNU in the counties of Chester between June 2015 and June 2016. In addition, under Section 17 of the Inquiries Act, the Chair must, in making any decision as to procedure or conduct of an inquiry, act with fairness and with regard also to the need to avoid any unnecessary cost, whether to public funds or to witnesses or to others. It is understood that the application to the CCRC is supported by the opinion evidence of an international panel of independent experts who have considered the medical evidence presented at Ms. Letby's trial. These experts are distinguished and recognised leaders in their field. They include Nina Modi, a distinguished professor of neonatal medicine at Imperial College, a past president of the Royal College of Paediatric and Child Health, the British Medical Association, and the current president of the UK Medical Women's Federation, who served with 2 Rule 9 requests by the ILT and has provided 2 witness statements to the inquiry. This new evidence merits and is therefore being given serious consideration by the CCRC, where there is a real possibility, as appears to be the case here, that Ms. Letby's convictions may be referred by the CCRC to the Court of Appeal and there quashed. We submit that the inquiry proceedings must be paused. To ignore the appellate proceedings which have now commenced would be wrong on 3 grounds. 1, the terms of reference are conditional on Ms. Letby's criminality, and there is now an active investigation into the evidence upon which her convictions are based. 2, the duty of the Chair to act fairly under Section 17 of the Inquiries Act. 3, the duty of the Chair to have regard to the need to avoid any unnecessary cost under Section 17. This is my taxpayers' money. There now appears to be a real likelihood that there are alternative explanations for these deaths and unexplained collapses, namely poor clinical management and care and natural causes. These alternative explanations were not put to the jury in either of Letby's Crown Court trials. Bazinga! There was no presentation of the RCPCH report, which the inquiry has now delved into in some depth. But, despite now being a live to the many problems that were present on the NNU over the relevant period of time, and there being alternative causes of death now being proposed with force and corroboration by Dr. Lee's panel of international experts and other UK neonatal leads, given the terms of reference, these were not explored by the inquiry as alternatives to murder. This was despite a letter to the Chair from Sir David Davis MP on the 29th of August 2024 expressing his reservations about the terms of reference and requesting that they be broadened so as to not depend on the presumption that Letby's convictions were safe. To continue to make findings on the evidence heard, given the filter through which that was drawn, it is to breach the duty to act fairly to those individuals and witnesses, as to require under Section 17 of the Inquiries Act. It also defeats the very purpose of any public inquiry, which must be to fully and fearlessly understand the circumstances in which these babies came to die or suffer unexplained collapses. If there is evidence to indicate that there are alternative explanations, then it would be wrong for the inquiry to ignore it because it is inconvenient. Nor would it be appropriate without more to make a determination about its evidential value at this stage. That is now a matter for the CCRC. Until there is clarity as to Letby's involvement, as determined by a proper and legitimate appellate process, the proceedings must be paused. If the inquiry is determined to continue to its conclusion, considering closing submissions, engaging in the warning letter process and drafting its report, it will do so in the absence of considering the alternative hypotheses that are now in the public arena. In doing so, it will be disregarding potentially serious and in some cases fatal issues that have been identified in the provisions of care at the Council of Chester. The inquiry has a duty to investigate, quote, the effectiveness of NHS management and governance structures and processes in keeping babies in hospital safe and well looked after, close quote, and identify what changes are needed to prevent similar tragedies from being repeated in the future. Well, Ms. Blackwell, I couldn't have said it better myself. Thank you.